Hey guys, welcome back. Joe Brunsman, insurance broker to the stars. I am joined by Daniel Astin, who is, I'll say, the lawyer to the stars. Maybe we can give you that title here.
Oh, that's
Um,
very that's very kind. I mean, you might be overstating a little bit, Joe, but I'm glad to be here. Thanks for having me again. It's always a pleasure.
hey, thanks for coming on because I know that you also work with a lot of MSPs, and not that you're giving legal advice here, but I think you've heard the same issues I've heard about, which are billing issues. Correct?
Yeah, I mean, what you do is you're running around and looking at, if you're looking at social media today, everywhere you turn, whether it's Reddit or anywhere else, it seems like MSPs are complaining to a greater extent than what you normally would see about billing practices. Now, it's anybody's guess as to what's causing it or bringing it to the fore. I think MSPs are generally very good about sharing information in the industry, so that's a good thing. But you've got a lot of roll-ups happening. It could be from the bringing together from multiple platforms for larger vendors, disparate billing systems, and maybe the transition's not there yet. It also could be a systemic issue for a particular billing program. We all would hope that it wouldn't be anything more nefarious than that. But it is, to your point, it's a real issue for MSPs today. Um, Billing issues that come up from vendors. What are you seeing, Joe? What's your experience?
Yeah, so I've had multiple MSP clients of mine. Like I said, I'm just their insurance guy, but they call me anyways and they go, "Hey, I just got a bill for $5,000, $10,000 of something that I've had cases of I've never used this software. I haven't used this software for 4 or 5 years. That's not what my contract said." Kind of multiple different, I'll say like flavors of discontent on the MSP side. So a lot of them ask me, like, "Hey, what do I do?" To which I reply, "Hey, I'm not your attorney, right?" But then I guess kind of the broader question here is what's like a good first step for these guys? I mean, do they need to go straight to, "Hey, I have to squirrel away a bunch of cash and try and sue this behemoth company?" Or what do you think's the good kind of first easy step there?
Well, we're getting the same calls that you're getting, and people just wanting a little bit of business guidance on how to proceed. I think a good first step is to notify them in writing that you've got this discrepancy. You usually dealing with somebody on billing, credit manager, whoever your point of contact is on billing, and just jump on it right away. I wouldn't let it sit and say, "Hey, I've it's irregularity. Here's what I think the bill should be. Here's what I think is what's wrong with it.
Mhm.
Can you check your records and tell me whether you agree with me or not?" Because always the best thing is in any business relationship is when you're dealing B2B is that quick uh, contemporaneous communication so that everybody has an opportunity, their best opportunity to fix it to everyone's satisfaction. That would be my first step. Just reach out.
Would you recommend, hey, if you're going to call your rep at this company, maybe follow that up with an email so you have some type of evidence that you tried to play nice to begin with?
Yes, I would do. I'm a big fan. I mean, it was, using a typewriter before the internet in grad school. I'm a big fan of picking up the telephone. I think that still works the best. People like uh, face to face or voice to voice communications, notwithstanding that we live in a digital world.
Mhm.
And yeah, I think it's a great idea. I would always recommend putting something in writing so you have something for the file. So there's no clear, concise, don't point fingers in the first communication. Don't, disparage anyone. Just an amicable statement of the issue, what you think the solution is, and leave it at that. And that way, a month, 2 months, 3 months down the road, whatever it is, you have at least some clear evidence of what the articulated issue was. It's up front, you articulate the issue, articulate what you think the problem is, and propose a solution. I think everybody in every business in every space can appreciate that.
Got it. Now, let's presume nothing happens, right? The rep at whatever, let's say, software provider, they go, okay, noted, thanks. And the MSP still keeps getting bills for that amount, right? With late charges, or their credit card wasn't refunded that amount. What would be some potential next steps that an MSP should go for? Is it, hey, straight to lawsuit? Is there go to the attorney, maybe have your attorney write a letter? What would you think from that point moving
So,
forward?
so after assuming you're exhausted, you've pinged your rep and nothing's happened and you're still getting billed, then there's I'd escalate it just as you would with any other problem within your own company. I'd escalate it to the next step, next higher up in management, following their chain of command, and seeing if you can get it resolved there. I mean, nobody benefits from kicking the can and allowing that accounts payable on the MSP side and the AR on the channel partner side to accumulate over a long period of time. But you got to give everybody a reasonable opportunity to solve the problem. If your rep is not doing it and you think you've exhausted there, I would say, hey, just a heads up, I'm going to escalate this. And, and it might help if you say, hey, listen, I've escrowed, I've set aside the amount that I think we do owe. But I do want to get this problem resolved because I don't want to pay without an acceptance or the decision at the vendor that says, yes, we agree with you. And so we're going to credit back or refund if you've already made the payment, you refund it back to you or credit it against the next bill. Some reasonable business solution. But I would go to escalation before I would go outside the company, or certainly before you do any lawsuit, because most of the time, if it's a month or two, it's going to cost you more to litigate than it is to what your potential recapture is, because presumably it's a partial number. You owe something for what you got, but your contention is that it's overstated, either because you didn't get the services or because you didn't have as many seats. You had 2,000 seats and you were billed for 2,500 seats or something like that.
Got it. So that I guess leads to the inevitable kind of follow on, which is we've already spoken about the back end. Like, what are kind of some practical steps you can do once you get this bill and you're trying to dispute it? What about the front end? Because I've seen a lot of contracts from these vendors and they're not very, I'll say, mutually beneficial as far as working out some of these disputes. So, what would you say on the front end are kind of some concrete things that you could potentially try to negotiate within your contract so that way moving forward you can minimize the odds of having to deal with this type of stuff?
Well, you can always have a provision for uh, an the account if it goes into a stalemate, end in sight, and it's looking like it's going to go to some contested matter. One party or other believing the other is in material breach, then you could build in a provision that allows you to get it. So a lot of MSPs, whether it's on the customer or the other end, you could build out, let's say it's a 36-month contract. You could put it out in 18 or 30 months with 10 days notice. And that helps you because if you've got a dispute, you have a certain runway to resolve it, and you're only going to be in so deep until you're out, and you can switch vendors. Alternative dispute resolution, mediation, you can build that in. And it's, you can do that, do the mediation 100 different ways. You can do it on a limited basis. You can have how you resolve the dispute as to billing. That can be its own, silo. And I've seen that. Not many people, most people try to protect themselves by having provisions, the bet the farm positions when the relationship is totally imploded. It is a good idea to consider whether you have a mechanism to resolve disputes where you want to continue the relationship. You like the services that you're getting. You've got a good relationship with the people that are providing it, but you want to resolve the billing issue. And that would be in everybody's best interest. Things I wouldn't do, because the average MSP is going to have literal firepower and leverage over a large public or private vendor, because I wouldn't waive my rights to the jury trial or to be a representative, for example, in a class action, in case there's system-wide billing issues or industry-wide billing issues with a particular vendor or vendors, unless I talked with an appropriate professional, like your lawyer, whether it's your big enough to have an in-house lawyer or an outside lawyer on retainer, or whether it's your business lawyer that you consult, on Main Street, wherever you're located. It's always good to go at that point and get that advice as to whether you should give up certain dispute resolution or litigation rights. You want to protect yourself as much as you can. It's a risk management tool, and it limits your downside and increases your opportunity to resolve disputes, or as I said earlier, if you have an out, to get out of the contract rather than having to wait until its a logical conclusion for the full term.
Got it. So, in my experience, I've felt that, or I should say, I've had a lot of MSPs say, you know, who am I to tell this big organization, right, what these particular terms of the contract are going to be, right? Maybe they're a $1 billion organization. I'm a $500,000 MSP. But actually, and tell me if I'm off base here, generally the sales guy on the vendor side, he wants to get the sale, right? Because his compensation is probably linked to that particular sale. And so I say, hey, why not just try, right? Obviously, with appropriate counsel to make sure that you're doing the right things and potentially what you want to dispute, et cetera, et cetera. But is that your experience where even, say, the little guy can start kind of adding and changing some of these terms to be a little more beneficial for him?
Well, I think anybody can ask, and certainly the little guy is going to have less leverage on big tech than some of the software that professionals like you and I use every day. We're not going to be able to change a comma on that EULA or on contract. That's not going to be realistic. But where you have a vendor, where you're an MSP and you're outsourcing, or you have a vendor that you've had a very long-term relationship with, or they're providing multiple services in the stack, you may be able to modify some things. And it always comes down to the practical realities of business and who has the leverage, but it can never hurt to ask. Not everybody has access to an attorney. Not everybody can have access to an attorney. There are probably 50, 60,000 MSPs out there, and many of them are startups or early stage or are family run businesses. They can't afford to run to an attorney uh, every time they have a problem. But my experience has been a lot of them are very savvy. They understand the from a layman's point of view, the legal concepts. They understand the provisions in the contracts. They know where their risk is, and when there's when they see a provision that they think is unreasonable for the context of the relationship, it can't hurt to ask, because as you think you're alluding to, they can only say no.
Exactly. And do you think maybe a potential leverage point for the average MSP would be, hey, maybe if we can't change these contract terms, I'll only sign maybe like the 1 year contract. But if you're willing to change the contract terms that you spoke about, maybe then I'll sign the 3 year contract. Could that
Sure.
be
I
some
mean,
leverage?
you don't want to lead with your chin. You want to offer something to the other side. You do this for me, and I'll do this for you. A lot of it's going to be depend upon the length and the depth of the relationship. If you have an MSP who's going to do a contract, if I'm going to do a contract with you, I'm the MSP and you're the vendor, and I have 1,000 endpoints. It's more likely that you're going to listen to my concerns and maybe be able to move on my concerns than if I had 100 endpoints. And
Right.
more likely if I have 1,000 endpoints and we've been doing the business together for 10 years than if I've got 100 endpoints and we're doing business together you know, for the first time.
Exactly. So to put a bow on all of this, let's see, we spoke about really kind of two things. One, what are some kind of concrete actions that you can utilize as an MSP owner on the back end once you get a bill that you don't think is appropriate or justified? And then on the front
Right.
end,
And
what
we've covered it on the back end. You communicate and memorialize your position in writing. And on the back and
exactly?
on the front. Yep.
Yeah, and then the front end is see what you can do to work on those contract terms so that if a dispute does later arise, you have a little better position as the little guy to try and remedy, I will say nicely, any dispute you have with the giant behemoth.
And that's right. And the other thing I would do is I would look at the choice of law, choice of form, the venue, where, if you're going to
Mm,
have a dispute, whether you're going to resolve it through mediation or arbitration or through litigation, where are you going to bring, where does either party have to bring that claim or dispute and under what law? If if you're in East Tennessee, you may want to bring that in East Tennessee. You're very comfortable with where you are and all your businesses in East Tennessee. That's perfectly fine. You just have to make sure that you run it by uh, somebody. If it's sounds, looks, smells, feels onerous, then run it by somebody. I mean, there are a lot of good. The one great thing about the U.S. is that 50% of all lawyers are under 50 lawyers. A great percentage of lawyers are sole practitioners. There's a lot of small firms out there that do a really nice job of servicing small business in the community. And I think a lot of times that is overlooked. Not every, you know, where we primarily practice in Delaware, a lot of great lawyers in Delaware, but Delaware is not the only place that there are great lawyers, and not all great lawyers are with big firms. I know a lot of sole practitioners that are really fabulous lawyers and do a really great job at servicing small business clients. So I wouldn't overlook that opportunity if it presents itself.
That's actually a great point because I remember looking at a vendor who shall remain nameless, and they said that the venue of dispute was, I never knew that Old Jersey actually existed. I guess makes sense that there's a New Jersey, but it was Jersey Channel Islands. And I went,
Right.
where the hell are the Jersey Channel Islands? So I
Yeah.
looked it up, and it's some odd mix of, uh, let's see, common law, which is UK. What's the French system that they use down in Louisiana as well?
The Code Civil.
Yeah, so like Code Civil and then
Yeah.
Norman law, which I'd never even heard of. And so, sitting there thinking to myself, I'm like,
Right.
how could how could any MSP possibly
The
deal
answer is
with,
they can't. It,
yeah,
it's really it's really it's really overreaching, and uh it's difficult to see any reasonableness in expecting a small business to go to the Channel Islands to resolve a dispute,
Yeah.
right? So, but I haven't seen that, but I don't doubt that it does exist. But it's people want to limit their liability. I always say the greatest way to limit your liability is to be transparent and provide really good services, and build that relationship. That's the best way to stay out of trouble. That should be your first line of defense, is to do what you do really well, and do it to the greatest extent you can, better than your competitors. That's the greatest way to it's the best way to stay out of trouble always. If you have to run off to resolve your disputes from Poughkeepsie, New Jersey in the Channel Islands, then I'm going to suggest that relationship gets off to a rough start.
Very true.
My
All right.
non-legal opinion. So, yeah.
Very, very sage advice. Danny, thanks you again
Thank you,
for
Joe.
joining
As
me.
always, a pleasure.
All right.
Cheers.
Appreciate it.
Fair
All right.
winds,
I'll see you
fair
around.
winds and following seas. Cheers. Uh-huh.
Always.